When an appeal is dismissed, we hope the court will uphold justice. What do you need to know when you go to court? Welcome to this segment on plaintiffs in administrative litigation. Let us answer your questions. Before you file a complaint, how to reverse an administrative act or traffic ticket you disagree with. After receiving formal notification of a decision or adjudication of an administrative appeal, please remember to file a complaint with the administrative court to reverse the punishment within the statutory period. You must make your demands clear in your pleading. So, how do I write a pleading? You can visit our website and our AI customer service assistant can help you. Just enter a term in the search box. You'll find templates and examples as a reference. The plaintiff can refer to the examples of administrative litigation pleadings and fill in any template step by step. Filing a complaint against a government agency. Next, in the contents of a pleading, the statement of claim requires that you write down specifically how you wish the court to deal with your case. Write down what took place between you and the defendant and your reasons for the complaint in the Reason and Facts section. In the Evidence section, provide any documents or evidence to prove your claim reasonable. If you encounter a problem, you can ask a lawyer to assist you. And if you are eligible, you can get free legal aid provided by the Legal Aid Foundation. After completing your written pleading, you can mail it or submit it in person to the court. You can also file a lawsuit online on the Judicial UN's website and apply for a remote hearing at the same time. Quick reminder, please attach the notification letter of the decision of the administrative appeal, if any, while handing in the written pleading. Remember to deliver these documents before the court date. In accordance with regulations, the plaintiff must pay any court costs to file a suit. After any litigation has been resolved, generally, the losing party is liable for all court costs. Courts offer convenient payment options. Feel free to make use of these payment options and keep an eye on payment deadlines. Understanding the hearing notification letter. After filing your lawsuit, you will receive a notification letter if a hearing is necessary. But what parts should you pay special attention to? First, you should note the contact details of the court and the clerk in charge. Once you're at the courthouse, you'll give your case number to court personnel so they can check on your case. The cause of action refers to the type of administrative litigation as characterized by the court on the basis of the facts mentioned in the plaintiff's pleading. The defendant column tells you who your opponent is in your case. Conversely, the defendant can also find out who the plaintiff is by looking at this column. The time of arrival indicates the time the proceedings are scheduled to begin. Note the location of the proceedings, including the courtroom number, to avoid going to the wrong place on the day of the hearing. The type of session reveals what the court is prepared to do on the court date. The most common sessions are preparatory proceedings and oral arguments. A preparatory proceedings session confirms the claims of both parties and investigates the evidence in the case. An oral argument session is when both parties try to persuade the judge to rule in their favor, according to the results of the evidence investigation. The notes column will give details of anything you need to pay attention to during the court hearing. What should I do if I can't attend court on the designated date? You can appoint an agent ad litem. In principle, this agent ad litem must be a lawyer. Only in certain circumstances can you appoint other people, but you must ask the court for permission. If you have a valid reason for not attending court in person, but don't have an agent ad litem, you can apply for a leave of absence from the court in writing. If it's on short notice, please call the court in advance. When you receive notification of the oral argument session from the court, and if you or your agent ad litem will be absent without a valid reason, the court can declare a judgment solely based on the defendant's statement. Beware that your absence without a valid reason will impact your rights and interests. Remember, feel free to contact the Joint Service Center at any court if you still have questions or need other services. Preparing for court. The day you are set to appear in court arrives. If the court has agreed to remote proceedings, please refer to the Remote Court Proceedings Handbook in advance. For more information, you can scan the QR code in the top left corner. If you are attending court in person, remember your appearance should reflect your respect for the court. On that day, remember to bring your ROC ID card or other identification, your notification letter, and any other required documents indicated in the notification letter. If you wish to bring additional documents for the court to consider, remember to prepare extra copies for each defendant. Ideally, you should register your attendance at the court early, giving yourself time to find the courtroom. Please make use of public transportation when possible. Don't forget to log in a bit early if it's a remote proceeding. There are 2 ways to register your arrival at court: at the counter or the check-in kiosk. Then, wait for a court attendant to call you in. If it's not your turn yet, you can either stay outside in the waiting area or sit in the public gallery inside your appointed courtroom and listen to the current session. If the appointed time arrives and your case hasn't been called yet, the previous case may have gone over on time. Like hospital clinics, courts hear several cases every day, so please be patient. You can check the progress of the previous case on the court's website or on the LCD monitors outside the court. After entering the courtroom, please remain silent and be respectful. Court procedures and your rights. Private recordings of sound, images, or photographs are not permitted inside the courtroom. If required, you can apply for a CD recording from the court after proceedings are complete. Now I'll take you on a tour of the courtroom. At the front is the judge's bench. Below the judge are the court clerk and the court interpreter. In the center is the witness stand. The plaintiff and their agent ad litem are on the right. The defendant and their agent ad litem are on the left. Witnesses and other relevant persons are in the spectator gallery waiting to testify. Before proceedings begin, write down your claims in a written pleading. When proceedings begin, the judge will allow you to speak, so please be patient. When the judge asks you for an explanation, you only need to state the important points. If the judge is unclear on any parts, they will ask you to expound on them. If you're worried you can't explain things well, you can submit a supplemental written pleading. The judge will also ask the defendant to give their account. Please respect your opponent's right to defend themselves. Do not interrupt them. If you want to counter, please raise your hand. You may speak again with the judge's permission. In court, the clerk will make a written record of the main points of the proceedings. Everyone will have a computer monitor to view this record. If you discover an error or misunderstanding in this record, you can report it immediately. The court will organize all the information from the proceedings and bind these documents in order in a case file. It contains records of what the judges, litigants, and witnesses said in every court hearing. The litigants can apply with the court to review the case file during the proceedings or apply for the case file on CD. If the judge thinks that the court has clarified everything, the required investigation, they will announce the conclusion of the oral arguments. If you have any evidence or material you wish to present to the court, you should do so before the judge announces the conclusion of oral arguments. Otherwise, in principle, you will not get another hearing in court, and the material you wish to present will not be considered. For cases that have concluded their oral arguments, the judge will subsequently announce the judgment day in court. On the judgment day, the judge will announce the judgment in court if any litigant attends. The court will send you a written judgment regardless of your attendance. Going to court is not as difficult as you might imagine. So let's protect our rights together.